Chapter 2 of the Risk Management Guide covers the mandatory standards that all CLCs must be aware of and comply with. It is important that anyone commencing work in a CLC, but especially a lawyer, is familiar with this part of the guide. The mandatory standards will be highlighted in this presentation. We will also explain how the matters listed in Chapter 2 are then dealt with in more detail in later chapters of the guide. Open your copy of the guide to Chapter 2 so that you can refer to the sections and paragraphs as they are discussed in this presentation. You will see there are 8.5 pages of mandatory requirements broken up into 21 headings. All members of a Centre's Management Committee, or board, and all staff and volunteers, both legal and non-legal, should be aware of all the mandatory standards set out in this part of the guide. The first requirement of the guide is that each centre must appoint a responsible person to perform the role set out in the guide. This appointment must be in writing, and the centre must advise their state PII representative who they have appointed. The person appointed as the responsible person should be a centre employee who is a lawyer with an unrestricted practice certificate. Where this is not possible, the guide outlines the process that should be followed to appoint someone else as the responsible person. More information about the appointment of the responsible person is set out in Chapter 3 at paragraph 3.6. Each CLC must support its staff and volunteers to comply with the guide's mandatory standards, develop policies and procedures to minimise risk of claims, and ensure that workers and management committee members are familiar with these policies and procedures. A centre must provide their responsible person with support and resources to ensure the guide is implemented. Insurance. The mandatory standards relating to insurance are simple. All lawyers must be covered by professional indemnity insurance that satisfies the statutory requirements in their jurisdiction. To ensure they are covered for any potential claims, centres must describe all services they provide in their initial application for PII and on the annual renewal application. These include any specialist, auspiced, or hosted project or services. To be covered by the PII policy, a centre must notify the broker or insurer in writing as soon as possible about a claim or loss and any facts or circumstances that might give rise to a claim. We will return to this later in the presentation. Turn to paragraph 7 of Chapter 2. This paragraph sets out the requirement for any lawyer practicing as a lawyer at a CLC to be admitted to practice and have a current practicing certificate. If they are a restricted practitioner, then it is the responsible person's job to make sure that adequate supervision is provided. Paragraph 9 refers to the requirement in the Migration Act 1958 for a person who is going to provide immigration assistance to be registered as a migration agent. Again, it is the responsibility of the RP to ensure anyone providing such assistance has the appropriate qualification. What are the requirements regarding other professionals? Any other professional working in the centre, whether as a volunteer or in any other capacity, is required to abide by the relevant codes of conduct for their profession in their work at the centre. This includes registered migration agents, financial counsellors, and social workers. One of the most important obligations centres have is to ensure they comply with their duty of confidentiality which is owed to their clients. Turn to paragraph 12 of Chapter 2. This sets out the obligation for all management committee members, staff and volunteers at a centre to comply with all ethical, contractual and statutory duties of confidentiality. These duties are owed to all the centre's clients, including clients of auspiced or hosted services, projects and branch offices. Any statutory or contractual requirements for information privacy must also be complied with. In Chapter 6.6, there is more detail about the duty of confidentiality and how it may arise. A contractual duty can arise through a service agreement or client agreement. An ethical duty can be informed by a code of ethics or code of conduct, or a statutory duty can be created which is governed by professional regulation or a particular legislative scheme, such as the legal profession conduct rules. Privacy laws exist at a state and federal level, and it is beyond the scope of this session to consider which of those might apply to a particular CLC, but it is worth noting that a CLC which would not otherwise be bound by the Privacy Act may have agreed to comply with various privacy principles under the terms of a funding agreement. For example, the current CLSP service agreement includes a requirement that a centre comply with the information privacy principles set out in the Privacy Act 1988 and any applicable state or territory privacy legislation. There is more detail provided at Chapter 8.2. However, this is one area of the guide that requires more detailed information, and this is currently being worked on by the National PII Committee. Conflicts of interest. Now consider paragraph 13 of Chapter 2. This deals with conflicts of interest and also refers the reader to Chapter 6, which has a further 16 pages devoted to the topic. You may like to pause the presentation here while you turn to Chapter 6. As you can see, there is considerable information to assist you in understanding conflict of interest. This reflects the importance of understanding the steps that must be taken to ensure that a centre avoids conflict of interest. In order to do this, it is necessary to understand what a conflict of interest is, and the reason why proper conflict checking is required. The guide also provides assistance to centres where questions arise about whether or not a conflict of interest exists. The mandatory standards include the following. A centre must avoid conflicts of interest and must have a policy dealing with conflicts of interest and conflict checking. The guide annexes a draft conflict of interest policy at Appendix G. Pause the presentation to find Appendix G. Does your CLC have a similar policy? Have you seen it? A centre has an obligation to train staff to identify potential conflicts of interest and to know what to do when one is identified. A centre must conduct a full conflict check before providing advice or commencing casework for a client. Where an actual conflict prevents a centre from assisting someone, they should be informed that the centre cannot provide a service and be referred appropriately. They should not be advised that a conflict exists, but simply be advised that they cannot act for or assist them. Each client file should indicate that a conflict check has been performed. Go to paragraph 14. Paragraph 14 includes 17 mandatory standards concerning practice supervision, which are relatively straightforward. These include the requirement that the responsible person ensure that all staff and volunteers are adequately and appropriately supervised. The responsible person must first form a view of the level of supervision needed for each member of staff and volunteer at a centre, including those in auspiced services or branch offices, and then determine who is the appropriate person to provide the supervision. This may involve delegation of supervision of some staff to a nominated person who is suitably qualified. For example, an employed lawyer with an unrestricted practice certificate and expertise in family law might be appointed as the nominated person to check the advice and casework of the other staff and volunteers providing advice in family law. It is a mandatory requirement that the responsible person or a nominated person check all the advice and casework of volunteers in a timely manner. A significant proportion of advice and casework of non-employed lawyers should be checked, and a sample of advice and casework performed by employed lawyers on a regular, frequent, and random basis. Where incorrect or incomplete advice has been given to a client, the caseworker responsible must be alerted, the client given the correct advice, and the new advice recorded. The responsible person must check all law reform submissions, media statements, and CLE materials produced by the centre prior to publication. There is more detail about supervision in Chapter 7. It includes a discussion about remote supervision and the supervision of branch officers, and is an area where the guide includes guidance and discussion of issues that may arise which goes beyond prescribing mandatory requirements. See paragraphs 17 to 20 for the mandatory requirements relating to the creation and retention of client records. The main chapter that provides information detail about aspects of legal practice is Chapter 8. What information must be included in client records? All client intake records must include the client's name, contact details, type of matter, name or names of other parties, and an indication that a conflict check has been performed. Client files should each have a unique file number so that all advice records and client files are readily retrievable. Legal problems must be recorded in sufficient detail so the nature of the client's inquiry is clear. A record of advice or other information given and any referrals made must be noted in sufficient detail, and this must include the name of the person who provided the advice or made the referral. This record must be signed and dated by the worker. Clients must be advised of all relevant limitation dates, and the fact that this advice has been given must also be recorded. Any limitation dates must be recorded on the file and in a central location. If a CLC provides advice via email, they must comply with all mandatory standards relating to the giving of advice by this means. This includes the centre having an email policy that takes into account the risk management issues that can arise. See Chapter 7.6 and 8.5.6 to 8.5.8. There is a draft email policy at the Appendix F. A centre must not provide advice to a third party unless there are exceptional circumstances. Some possible examples are listed at paragraph 19.5 of Chapter 2. These include the situation where a person is incapacitated and the person seeking the advice on their behalf clearly acts with their consent. Where the staff member or volunteer is not a lawyer, they must disclose this to the client. Many centres have paralegals or law students who may deal with clients. They should advise the client at the start of the conversation of their role, for example, by saying the following words: "I am not a lawyer, I am a tenancy worker." There must be a record of each file in the centre's database, and this must include a record of when a file is opened and closed. For centres who receive funding under CLSP, this is a database called CELSIS. In some jurisdictions, it is compulsory to have a letter of engagement or client agreement signed at the start of the matter. This is not required in WA, however some centres use a letter of engagement or client agreement in all matters. Client files need to record relevant limitation dates prominently, including whether or not they have expired at the time the file is opened. It is also important to record any other critical dates, such as court dates on the file, in a central location so that these are not overlooked. File notes must be made of all telephone and face-to-face attendances with the client or any other person spoken to about the matter. So these notes must be attached to the file. Files need to include copies of all relevant correspondence and other documents. Importantly, a centre must ensure that client files remain confidential. This includes the obligation to keep the physical files in a secure location and to protect the client's electronic file by requiring strong passwords to access any computer. All centre data must be regularly backed up. Any mobile devices containing client information should be password protected, and portable data storage devices, such as USB flash drives, should be securely managed and stored. See the next slide for more information about closing a file. Before a file is closed, it must be reviewed by the responsible person to ensure that all requirements have been met. The clients must be advised in writing that the file is to be closed and that it will be destroyed after 7 years, or as is appropriate for that file, and they should be advised of any limitation dates. Any original documents should be returned to the client, and if applicable, any bills should be paid and all financial requirements met. The file's closing date must be recorded on the file and on the centre's central file register. Closed files must be archived in a secure environment away from unauthorized access for a minimum of 7 years. They should be archived in such a way as to allow easy access to check potential conflicts of interest and/or take copies of documents for clients. They can be stored electronically, so long as the system of electronic storage satisfies the key requirements of reliability, integrity, and accessibility as set out in Section 12 of the Electronic Transactions Act 2011, WA. Before a file is destroyed, the responsible person must consider whether the client has given consent for the destruction of any documents in the file that are the client's documents. It is usually easier to obtain the client's consent at the beginning of the matter, or when the file is closed, than it is when it is time to destroy the files. Special considerations apply to the destruction of files containing instructions for wills and powers of attorney. A centre should consider when it is appropriate to destroy such files. There is further discussion of this topic in Chapter 8 at the paragraph 8.15.6 to 8.15.9. For those CLCs who have CLSP funding, CELSIS records must be kept permanently. This brings Part 2 of the Risk Management Guide to an end. Legal practitioners will be required to complete a quiz to confirm their understanding. CPD points can only be awarded upon successful completion of these assessment activities.